Hello, I'm Adam Kielich, and this is the Kielich Law Firm podcast, episode 3. Today we're going to talk about social media and its role in litigation. This is sort of a hot topic, or has been, I guess, for a few years amongst attorneys, primarily just because the amount of information available by social media is so broad that it's very tempting to want to go out and try to find that information and use it in lawsuits, whether we're talking about divorces or employment cases or personal injury, or some of the other cases that it's used in. So we're going to talk a little bit about what kinds of things we mean when we say social media, at least as far as what lawyers might be interested in. We'll also talk about why it matters in litigation, how it comes up in litigation, and what sorts of things you, as somebody who maybe isn't an attorney but listening to this, might choose to do, or need to do, or need not do if you're getting sued, or if you're about to sue somebody, or go through a divorce, which is a lawsuit itself. There's certainly a lot of discussion amongst the lawyers and bar associations about social media and litigation. Not all of that is going to be interesting to people who are not lawyers, so I'll try to cut this down, keep it a fairly limited discussion, and really try to focus upon what you as a layperson or maybe even a witness in a law. There's been a lot discussed and written amongst lawyers and bar associations about social media and how it plays out in litigation. Certainly, it's a very broad subject, and there's a lot of technical discussion about it. As I've said before, I really do these podcasts for people who might be clients or just people who are not lawyers or within the legal system. We're just trying to understand some of this stuff, understand their rights, understand what to do if they're caught up in a lawsuit or considering whether they should sue somebody. So I'll try to keep the conversation kind of narrowed in on the basics. And of course, if you're about to sue somebody, if you are being sued, if you're somehow otherwise involved in a lawsuit, if you're a witness or maybe part of some third-party group that's gotten involved in somebody else's lawsuit, you should really talk to an attorney about your specific situation, what kinds of information or content you've put into social media, and what that lawyer can advise you about what you should or should not be doing. All that said, I guess that's a pretty good introduction. I guess as a quick housekeeping matter before we get into the content. I know it's been a little while since I've released an episode. In the first couple, I talked about whether I wasn't sure whether I wanted to keep doing that. I don't know. I seem to enjoy doing this, but between writing the blog on my website, trying to do that whole actual being a lawyer representing clients, plus to have a little bit of a private life, squeezing in doing these podcasts is not always something that my schedule permits. So it's taken a while, especially with the holidays, to get another episode out. But if by chance you've listened to a few of these and you're trying to figure out whether you should keep an eye out for any future podcasts, the answer is yes. But I don't know that there's going to be any kind of specific release schedule. I'll just kind of do them as I have the time to both sit down in a quiet place, record them, edit them, and then get them uploaded. So if you have any feedback about these podcasts or videos, you're probably seeing them on YouTube. Feel free to leave those comments. I know the video quality is pretty non-existent since you're just seeing a splash screen. The audio quality is not particularly great. I'm still working on a fairly crappy microphone. and I don't do a lot of recorded speaking, so it's kind of weird. And I know there's a lot of and pauses in the content. Sorry about that. I'm sure it'll get better with time. If not, uh, sorry. As I said in the past, we'll keep going with this and see where it goes. So let's go ahead and jump into it. First of all, let's talk about what that term social media means. Most people by now, even if they're not involved in social media, have heard the term, understand what it means. And for most people, they understand it to be these new sort of social networking sites. I guess they're not really new now since they've been with us for about 15 years or so. The major sites that we look at are Facebook, Twitter, sites like Pinterest, where maybe it's just reposting other content that you've seen, certainly is caught up in social media. MySpace certainly is social media. It was sort of it wasn't the first social media site, but it certainly was the first one to really get big. And apparently, even though for those of us who are adults who maybe were on MySpace once upon a time, that sort of fell off when Facebook got big. Apparently, the high school kids have gotten back into MySpace, and now it's sort of a popular thing because your parents aren't on MySpace to get on there. So we could certainly lump that in. There's also professional sites that we could lump into that category of social media. LinkedIn is a pretty good one. The term can be used pretty broadly to include blogging sites, Tumblr, WordPress blogs. Google has its Blogger or Blogspot, whatever they're calling it now. Typepad. There's some other ones out there. We could fairly call blogging a form of social media, particularly Tumblr, where it's almost more of a Twitter sort of. A lot of people use it to post real small, brief posts. Video and picture websites can also be considered social media. So, of course, Instagram, which is often tied in with Facebook, that's social media. We could fairly call Vine and some of these other video sharing sites social media. Some people still run sort of personal websites on their own where they post their own content without using somebody else's platform or tools. We could call that social media. So really, although we've talked about some of these particular groups or websites, social media could really be lumped together any kind of website where people share details about themselves beyond sort of the white pages kind of name, address, phone number kind of stuff with other people in a way that can be broadly accessed either publicly or semi-publicly through selecting groups of people who can access the information out of the public. I guess we could also, while we're at it, mention that. So we've got all these different websites that people use to share information or maybe not even share it, just kind of blast it out there into the internet. All of these websites come under the social media. So you have all of these websites, all of these platforms for social media or social networking. Sort of the key characteristics about these websites are that we use them to share information either with the public at large or with groups of people that we've hand selected. Think about like your Facebook friends. You could control who sees what information or whether all of your information is private. Twitter and Instagram, kind of the same way you can limit who has access. We generally also consider social media to include those websites where people are using the website as a third party to share the information, and that's really what differentiates social media from just, say, emailing, where you could email, that same information or pictures or videos to a group of people in the same way. An email uses a third party as well, whoever your email service provider is. But social media, we treat differently than email. We sort of pretend like email goes from sender to recipient the same way as we treat mail on like paper mail as going through the post office, that it's really just sent and received without the intermediary postal service or UPS or whoever actually seeing the content. With social media, we recognize that Facebook and Twitter as companies have access to be able to see and store and access the information. And for litigation purposes, that's an important distinction. So let's go ahead and transition and talk about why the social media matters in litigation. Well, the obvious reason why is that it's great information and great evidence about what a person did, what a person thought, who a person surrounds themselves with, what kind of ideology they have, where they go, when they go, places that they go. It's really such an incredible way to be able to access this huge amount of information about people. And quite frankly, it's information that you would never be able to access in any other way. People are very frank on social media. They tend to overshare details that other people maybe don't care about, or information that at least you might in person tell a friend or two, or the people that sit around you in class or work, but you would never think about like going out and telling every person you come across, this is what I ate for dinner last night. Like, people don't do that in person, but they will do it on social media. And we don't really care as lawyers about what you ate for dinner last night, but it might be important to know if you have a claim, say in employment, that, hey, you were supposed to be at work last night, but you didn't show up, and you say you were sick, and somebody sees on your Facebook account that you were at some new restaurant. Well, that could have problems for an employment claim, because now suddenly we know right out of your own typing or your own pictures that you were somewhere else. So not only does social media create a first-person set of evidence about the things you do, the things you associate with, your thoughts, your beliefs, your opinions, it's categorized naturally in a timeline. So we can go back and see the way that your activities progressed or your opinions about things changed. We can naturally tie certain things you did or said to a certain period of time. It's also great evidence to dispute somebody's testimony or assertions that they make in favor of claims in court, that they do a certain thing or they don't do a certain thing, and then you can roll out their Facebook account or their Twitter account and disprove and discredit what that person says. And it's, as I said, it's really hard to find the same volume and quality of first-person evidence. People usually don't create such detailed records of what they do or what they think at the time that it happens in the way that they do with social media. It's also the same kind of juicy details that jurors love to see. Like when you watch TV shows about court or lawyers, you really don't see them sitting down and talking about the boring details of a claim. What you see on TV are the like TMZ personal kind of details about what went on in somebody's life. And those are the kind of things that people share on social media. And as lawyers, we can go out and grab. People really think like, hey, just my friends are going to see this, no big deal. It's just like sitting at somebody's house gossiping with your friends. It's really not, because again, that record is created and made available to the third party. And we'll talk about a little more about why that third party nature is so important. The information can also be very juicy because it's very easy to take 140 characters out of whatever context it was meant and put it into a different context. And when we talk about the 140 characters, of course, that's the Twitter limit for content in a single tweet. So it's really easy to take a sentence or a couple of sentences and sort of disconnect it from whatever it was intended to mean and just read the words and allow it to take on a different meaning. Same with pictures or Facebook or Tumblr or whatever. It's really easy to take that small bit of information out of its context and pull it apart. And of course, that's the kind of thing that people hate about lawyers, that were, slippery and manipulate the facts. But social media makes it really easy to do that. It's perhaps even easier than email, because email, at least, people usually either sit down and really think through what they're writing as they write it, or it's written with a very particular person in mind. And it's a little easier to say, like, here's the particular recipient, here's who that recipient is, and why they would take what was written in a certain context. With social media, it's sort of sent out to a blank, generic public audience, even if it's just tied to your friends. And I mean Facebook friends, because that might also include coworkers who are barely acquaintances, family members, as well as people you actually consider friends in real life. So it's really easy to say, perhaps if you are having a private conversation or a semi-private conversation with your actual friends, that might have a different context from your grandmother on Facebook who also saw the post and would take something entirely different. So it's very easy to work and massage that information and the content and really turn it into a weapon both for or against its author. So that's sort of the opportunities to use social media, to use it to place people at certain places, to identify their thoughts, to identify their relationships with people. And that's all very useful. But let's also talk about how it becomes available to lawyers in litigation, so it can be used in all those different ways. The most common way that it comes up is during what's called discovery. Discovery is the name for a number of different processes in which lawyers or parties to a lawsuit obtain information and documents from the other people involved in the lawsuit. And the idea is, if everybody has to lay their cards on the table, it's going to encourage parties to settle and come to a more fair agreement, rather than do this kind of trial by surprise where nobody knows what's going to happen until trial, so you have to have a trial, and then it's very expensive for the parties, and you try to sandbag and ambush the parties. And again, that's the kind of thing you see on TV because it makes for good drama. You think about the 1,000 episodes or whatever of Law and Order there are. In almost every case, there's always the sudden confession on the stand or the sudden document that gets whipped out, and that's what, breaks the case. In litigation, that rarely happens, especially in civil litigation, because everybody has to put those documents out there, put the information out there, disclose what's going to show up at trial. That way, we don't need to pay for the court to set aside time for several days or several weeks. We don't have to run up all the other costs to our clients involved in litigation. We can just sort of see, here's the information. All right, let's see if we can settle this, knowing what the value of each side's position is. So part of discovery allows us to exchange documents, and we can exchange electronic information and electronic documents. And so when you think about the content that's out there on social media, you've got all those pictures, you have the text of any posts, you might have videos out there, you have likes, retweets, reposts, shares. That all signifies some sort of agreement or some sort of connection between you and whatever you've reposted or liked or whatever. You also have the identification of who you follow, who you're friends with, what kind of circle you've put them in, who you tag in different posts. You've got the time and date stamps on all of that information. You have the organizations or the concepts or the shows or whatever that you've liked and added to your account. So all that information is out there. That information can be obtained during this discovery process. And so all that information comes out and can be made available, and then some of that can come out during trial, during depositions. It might be used as hard evidence of some particular set of facts. And remember earlier we talked about the difference between social media and email, is that with email, we treat that email as though the servers in between sender and recipient don't see the content, even if they do store it. With social media, we do treat the third party, Facebook or MySpace or Twitter or whatever, that company as having access to and the ability to see the content. The important thing about that is it's no longer a private communication. It's a public communication. And we're allowed to go out to those third parties and subpoena them to get the information if the party won't release it themselves. Now, Facebook and Twitter in particular make it very easy to go in and get at least some of the information out of the account. They have a download option where you can download accounts. Now, it doesn't produce everything for that account, but it does produce some interesting information as far as certain things that people have searched for, what's called metadata, and that's sort of the hidden underlying data that's attached to that account. For Facebook in particular, it's the information that they use in part to sort out what advertisements to show you. Having access to that metadata can be pretty important because you can find out what kind of information people are looking for through their Facebook account. And that might simply be just another layer of information to get a glimpse into what that person thinks about or does or wants to do. So that can be useful as well, but that's sort of going off on a different tangent. My point about Facebook and Twitter and these other social media sites having access to the information is that there's no privacy to the information. You may have a private account that you only let particular people see. That doesn't matter for litigation. We can still go out there and get the information, if not from you as a party, but from whatever the website company is for the social media platform that you use. And of course, also keep in mind that whoever has access to your account, there's nothing that stops them from printing copies or making screenshots of what's available to them. So that's another way that that information can leak out. It might be the case, excuse me, that might be the case for, again, say an employment case where you call in sick and then you post something on Facebook to your supposedly private account, and one of your friends likes whatever you've done, or you've tagged a friend in that baseball game you went to, and your friend who was tagged is also friends with somebody you work with, and that somebody at work maybe is having to cover your work while you're quote unquote sick. That person might not be so happy with you and might show the boss, hey, you were at a baseball game and you tagged this other guy there, so you're just hanging out having a good time. You're not sick at all. Your employer might fire you because you are abusing their sick leave policy and being dishonest with them. And of course, maybe that's not a good example from a litigation perspective, but you can see from that how easy it is for social media to have a substantial impact on your life just based upon what some third or fourth party can see out of the chain of your particular posts. So once we get access to this information from discovery, or somebody else gives us copies of your information, it also happens in litigation. I guess to give a more specific example is in a divorce, the spouses are probably Facebook friends, which means whatever the wife has posted, the husband can see and make copies of. And even if the wife tries to hide her account or delete it or refuses to disclose everything, the husband might be able to go in there and see what's going on. Or maybe the brother-in-law is still on there as a friend, and he can go pull the information and print it for the husband, and the husband gives it to his attorney, and now that information is available for litigation. Once we have that information, it's almost unlimited in possibilities to be able to use that information because it's so broad and tells so much about a person. You can use it to bolster or dispute the credibility of witnesses, to establish timelines, to establish facts, to show that people have particular mental conditions or physical conditions. You can use it to build your own set of facts about what happened in a situation purely by the way that somebody posts. There are also cases where the actual posting to social media creates certain claims that result in litigation. This often happens in the employment context where somebody will post something disparaging about a coworker or their employer or a customer or a third-party vendor, and it gets back around to the wrong people, and suddenly people are losing their jobs or losing a job opportunity purely because of what they posted. It can become the subject of litigation, or you might even be sued for what you say on social media. No matter how private you might think your account is, like we said earlier, you don't know who has access to some of that information on the fringe because they're friends with somebody you're friends with, um, and you happen to tag them or whatever in a post. That information can become available, and once it's available to a third party, defamation can become a real problem with that social media content. Um, so really, just so much information, so many opportunities to use it. Uh, like we said before, so easy to massage the information and try to turn it into whatever you want it to be. So there's really a lot of liability to parties for what kind of information or content they're putting on social media. So if you are sued or you're going to sue somebody or you might be a witness in litigation, let's talk about what you need to do and can and cannot do with your social media content. And well, as I said before, you should really talk to your attorney in any situation that you might be involved with litigation and let your attorney know these accounts are out there. What do I need to do? And let your attorney advise you on the specific situation. But maybe you're going about this on your own as a pro se party. You don't have an attorney, or you don't have an attorney yet. Maybe you're just trying to collect information and figure out, do I need to hire an attorney? Am I going to pursue this claim? Am I going to get divorced? And maybe you're just trying to get your ducks in a row so you can go out there and be prepared. The single most important thing I can say is that if you are a party to litigation, certainly including a family law situation like a divorce or a modification or an enforcement of a custody order, whatever it is, you cannot destroy or delete information on your account. Cannot. This is something called spoliation. Destroying evidence in litigation is prohibited by the civil practice rules that govern litigation. And you might think, well, nobody's going to find out I broke the rules if I destroyed the evidence, right? And that's what people think when they destroy evidence. Well, the problem is, first of all, like I said, you don't know who has copies of the information, who has already made printouts or screenshots. You don't know what kind of information lingers in other people's accounts because they were tagged or posted, or what information you may be shared with a group that you can't take back. Also, the companies that run the websites like Facebook and Twitter, they have stored copies of the information. So your attempts to destroy the information may not even do you any good. But the real problem is your efforts to destroy the information under the rules permit sanctions against you, which means the court can charge you financially with a monetary penalty for trying to destroy or successfully destroying evidence. If you have an attorney who advises you to do this, first of all, don't do what that attorney says because it's prohibited. And your attorney can also be sanctioned in the same way. The court might also take more serious sanctions. They might what's called strike your pleadings, which means they'll cut out your claims or your counterclaims and prohibit you entirely from being able to collect, or might strike your defenses and leave you defenseless to the other person's claims. If you destroy evidence, typically the party seeking that evidence, the opposing party in your litigation, that person is going to ask the court to deem that evidence to exist and to exist in a way that's harmful to you, in the most harmful way it could exist. So if you delete a bunch of posts that show that you were having an affair in a divorce, the other party might ask for the judge to rule that those social media posts conclusively prove you are having an affair. Well, that's really not good for you if your spouse is asking for a greater share of the property because you were cheating. You don't want the court to say you were having an affair, especially if you weren't really having an affair. If you just had a friend of the opposite sex that was a good friend, somebody that you were leaning on during a bad time in your marriage, it sure might look like you were having an affair if you're posting about that person a lot on social media. But it's different to have evidence that could be disputed and evidence that does not exist that you no longer can dispute because the court has said we're going to act as though that evidence is there, and we're going to act as though the evidence proves without a doubt that you are having an affair. So you don't want to be in that situation. And like I said, it's very hard to successfully destroy all of that evidence anyway. So there's really very little for you to gain in even trying to get around the rules. Attorneys have gotten in some pretty serious trouble for advising clients to delete or destroy social media information. There was an attorney in Florida who was recently very heavily sanctioned as the attorney rather than the party he or she represented for advising that client to delete the Facebook account. So that's something you can't do. Don't go in there and try to delete your account. Don't try to delete posts or pictures or videos or friendships or whatever. But there are some things you can do. You can make all of your information private. You can suspend your account so that no more information gets posted or you don't get tagged by third parties somewhere. So the difference here is you can't destroy evidence that already exists, but you don't have to help manufacture new evidence. You can also choose just not to post anymore, and that's usually a pretty good idea. While we're sort of talking about the difference between preserving the old evidence and not creating the new evidence, we should talk about one gray area. And the gray area here is whether you can defriend people or stop following them on Twitter, however you connect with people on different social media platforms, whether you can break that connection. And there's sort of a question of whether it spoils evidence of the existence of the online connection. I think you've got to be careful about absolutely defriending them. On Facebook and Google Plus, you can sort of set up groups of friends or circles that don't have access to any of your account information. The safe bet might be moving people who are opposing parties or might be witnesses for opposing parties into an area where they can no longer access the account, but are no longer, but still have that connection so you're not destroying that existence of the prior relationship over social media. But there's not good evidence that says, or good rulings from the court that we can point to that prove that you're violating that rule and destroying evidence by defriending or breaking that connection between the other person. So that's really something you should talk to your attorney about and sort of weigh out your options and let your attorney advise you in that gray area. Something else you can do, though, getting back on track, is definitely you should not post information about the other parties in the lawsuit or the lawsuit itself. Don't make information, or don't create evidence that might be harmful. Don't add insult to injury. Don't create problems for yourself by talking about how you think the judge is a jerk or you're never going to agree to a settlement, uh, or you're not going to take the deposition seriously and you're just going to lie the whole time. People do post this kind of stuff on Facebook or whatever social media platform they have. If you go out there and get that information, that's going to be real damaging to your case if the other side shows that you're not acting in good faith as a party to litigation. So don't do that. Like I said, you don't have to create new information or new evidence that might hurt you. So just don't do it. It may or may not make sense for you to continue posting to your social media accounts in the way that you have in the past. That can all be pretty dependent upon what your claims are, who the other parties are, whether it makes sense for you to continue doing that. And of course, that doesn't mean that you should start fictionalizing social media posts to help create evidence in favor of your claims. But you may have particular claims where you want to show that you have healthy relationships with people, or show that you're involved in somebody's life. If you're already doing those things, then it may be important to your claim to continue doing those things in a natural way. That's probably more true in family law cases than personal injury or employment or something else. And again, that's really an area where you should talk to your attorney about weighing out the benefits of continued posting versus the risk that you might post something that is harmful to your case. So I think we've gone on pretty far. This is a pretty long podcast. I think that gives you some good ideas about really thinking about what you're posting on social media and how it can affect the kind of claims you have, or what kind of defenses you can bring about in court if you get sued. So I would leave you with just a couple of key issues here. First of all, always think about the consequences of what you post on social media. It's so easy to post on there and hit send or post before you really think about who's going to see it or what's out there, especially if it's late night and you've had a few drinks. It's probably the wrong time to drunk tweet or post on Facebook. Try to really think through that. And secondly, if you are sued or you're in any way involved in litigation, keep in mind that rule against destroying evidence, because that could be really bad for you down the road. So I hope this has given you some good stuff to think about. If you've got some feedback or there's something you want to see in the next episode, feel free to leave those comments in the bottom. If you just want to tell me the audio quality sucks and you hate me as a person and you think lawyers are terrible people, I can't stop you from posting it, but it's probably not going to stop me from creating videos or doing my job as a lawyer. So good luck with that. So I think this is a good place to stop. I hope you enjoy the rest of your day, and if there's something that I can do for you and you're somewhere in Texas, feel free to contact my office and we can discuss whatever you've got on your mind. You can also go out to my website. I've got some other information about social media and its involvement in litigation. If you've got some questions or concerns about an area of law I practice, there's plenty of other content on the website for you as well. So that's it. So thanks for listening, and hopefully I'll be back with another episode soon.